Hi, everybody, and welcome back to EBnet.Stream. I'm joined today by Deirdre Phillips and Nadine Mather, who are both partners at Bowmans, in response to their recent survey on the Guide to Data Protection in Africa. That was, we've actually published it on the site recently, and there's some interesting findings in there that I thought I'd connect with them to understand what's happening in the rest of our continent, and then from a retirement fund perspective, whether there is anything we can learn in terms of what we can expect and what we can be implementing to make sure that we are ready. So Nadine and Deirdre, welcome to EBnet.Stream.
Thank you very much.
Nadine, I'm going to start with you, and perhaps you can share with our audience some of the highlights that came out of this guide that you guys have recently published.
So the guide that we published really was a survey of the various stages where African countries are at in their regulatory journeys in respect of data protection. And what we found from the survey is there's certain countries such as Ghana, Kenya and Mauritius who have very well developed data protection laws. They are comprehensive, they've been in place for quite a while, and they're quite far on their regulatory journey, with challenges being made to courts and decisions sort of coming out. There's then a handful of countries such as Botswana and Ethiopia and ourselves in South Africa, where we have enacted comprehensive data protection laws, but we're still relatively at the beginning of our journeys. It's still being tested. There's this big emphasis on education around the laws and understanding what it requires. Whilst we're seeing some enforcement action, it's not quite yet at the stage of where sort of Ghana and Kenya is. And then you do have, on the other hand, certain countries that are not yet where they should be on the regulatory journey. For example, you do have Namibia, who has the right to privacy, but they haven't yet enacted a data protection piece of legislation. There's a bill in place, but they haven't yet quite got there to enacting the legislation. And I would say they're slightly behind the curve. Where this has come about is obviously as a result of the European General Data Protection Regulation. And that came into force in 2018, but bearing in mind there was previous data protection legislation in Europe. And that really set the gold standard globally for how countries should be regulating how organizations and businesses and people process personal information. So what has become apparent is that whilst there are some unique requirements under the laws in respect of your different countries in Africa, all of them appear to have taken guidance from Europe, and the data protection principles really mirror those that are adopted in Europe. And by that, I mean, we're talking about processing in a manner that is minimal, it's adequate, it's for lawful purposes, you have adequate safeguards in place. Those principles all come across in respect of all the African jurisdictions that have data protection legislation. So yeah, the guide really is a survey to see where all countries are at in the process, and it's just demonstrating this move to ensure that all African countries at some point are going to have comprehensive data protection legislation, which businesses and retirement funds will have to comply with.
You speak about instances or enforcement instances as examples in some of the more experienced countries in Africa. Is there an example off the top of your head that we could learn from?
So not off the top of my head, Natalia. I mean, when we say every country who has at least implemented comprehensive data protection laws has designated a regulatory body to obviously enforce those laws. And they're seeing action in respect of complaints being lodged to the enforcement bodies and responses. And we're no different in South Africa. Whilst we're not necessarily as far as Kenya is, we, at least in the last 2 years, have seen a really proactive stance from our information regulator. In 2020, when the Act came into force, there wasn't a lot of movement. There was a lot of time spent educating organizations what's expected, what does it mean, what are your obligations. And 2 years down the line, the regulator decided now's the time. Everyone knows what we are doing. Everyone knows what the requirements are. So we are now going to take steps to proactively enforce that. And from our perspective, that obviously can be in response to complaints which we've received, but the regulator specifically on their own initiative has been visiting organizations to assess their compliance with our data protection laws. And they have resulted in enforcement notices. Several enforcement notices have been issued. And at least I can say for South Africa, there's been 2 fines issued to date. Unfortunately, they're both against South African government organizations, being the police, SAPS, and the Department of Education. But it just shows this move towards more proactive enforcement and compliance, and the issuing of fines is a possibility in South Africa.
Thanks, Nadine. I think what we're talking about is POPIA, just for our audience, because I think we're all a little bit kind of stuck in the joint standard 2 compliance requirements around cybersecurity and resilience. But Deirdre, perhaps you want to jump in here and share with us, when we look at this report in an African context, and then we look at it in a retirement fund context, what are retirement funds experiencing in South Africa when it comes to data protection right now? I mean, as far as I'm aware, we haven't seen an instance yet, or a fine, let me say a fine, but where are we seeing breaches that other funds and the industry could learn from?
So I think probably retirement funds are a bit different in the sense that, when we absent the POPIA Act, the funds trustees already had the obligations in the Pension Funds Act to act with due care and all of those, common law and fiduciary obligations. And there, our regulator, I think it's even in PF 130, had said the protection of information and protecting data and ensuring that your records, all of those things, which, I mean, some of it is already is now contained in the POPIA Act. So I don't think it's really anything new from a retirement fund point of view. Cybersecurity obviously is something different. Yeah, I'm also not aware. I mean, Nadine had mentioned there's only been 2 fines, and those have been SAPS and the government on education, but no retirement funds that I'm aware of. And certainly the FSCA hasn't been at all, to my knowledge, involved in doing any investigations to, check whether the systems are appropriate, whether the files, whether or not retirement funds actually, or the trustees actually comply with those various duties.
So my question, and I'm not sure who's more appropriate to answer this, perhaps Deirdre can start the answer, but POPIA also goes into the opportunity for, or it's not actually POPIA, I think it's PAIA, the opportunity to gain access to information, to understand what information a fund holds. And funds need to report once a year on their PAIA requests that they've received. Deirdre, perhaps you could explain, because the deadline for that has just passed at the end of June, I think. Perhaps you could explain why that is necessary. And Nadine, perhaps you could overlay something, if there is anything like that across the rest of Africa.
I'm going to bounce this one to Nadine for her to go first, and then I'll relay on the retirement fund, but just generally on PAIA, how that works.
Sure. So obviously in terms of PAIA, there's always been an obligation on public bodies to report annually to, it used to be the Human Rights Commission, now it's the Information Regulator, on the number of requests for access received during a specific 12-month period. And the purpose of that, as demonstrated in the Act, was for the regulatory body to be able to report back to Parliament on the workings of the Act, who is using it, what types of requests are we seeing, and bearing in mind this is an obligation on public bodies because it's records they hold where someone doesn't necessarily have to, well, they don't have to show that they're exercising a right in respect of requesting those records. When the information regulator took over the sort of monitoring and enforcement of PAIA, it noted that there was a provision that said they could invite private bodies to also provide a report. And the regulator decided that it was necessary actually for all private bodies to submit a report. We are inviting you to submit a report, and whilst it's an invite, it actually is a requirement once invited to submit it. And again, this is really to provide the information regulator with more information to understand who is using their rights under PAIA, what type of information is being requested, are bodies complying with their requirements under PAIA in terms of how they respond to the request. Are they doing it in a timelessly manner? Are they actually giving access? Are they refusing access, and why? So it really goes more towards the regulator gathering information to ensure that the Act is performing its purpose. Organisations are actually complying with the Act, and they can use that to report back to Parliament and government to show that this Act is achieving the purpose of realising individuals' or bodies' rights to obtain access to information where they're entitled to do so.
Yeah, and then I think one also then gets the abuse of that when, I mean, just taking it back to the retirement fund space. We typically see requests for, access to information, requests for information when it comes to death benefits, right? Yes. So a lot of that, where a beneficiary wants to know who the other beneficiaries are, how much they receive, etc. Where I know many funds have actually pushed back and said, it is confidential information. But you may know that recently, in fact, in one of the POPIA pension funds adjudicator cases, the adjudicator cross-referred to one of the FST cases where it was made clear that, in fact, when the adjudicator does investigate these complaints, that all of the information that was placed before the adjudicator, which was before the board in investigating a 37C death benefit, needs to be given to the adjudicator. And then we know when this eventually goes to the FST on reconsideration, the adjudicator's record is filed, and which would include all of the information the fund had given the adjudicator. So there's, then, clear splurge of information out there, but where do you draw the line as to what you're actually entitled to when it comes to requesting information, specifically as far as it relates to death benefit payments?
EBnet is proud to bring you top quality content from experts across the financial services industry in South Africa and internationally for free. Your support helps us in doing this. All we ask is that you subscribe to our channels by clicking the subscribe button below. Share this video with others you think will benefit from it, and give us thumbs up if you are enjoying the content. That way, you help us help you. Thank you from the team at EBnet. For more great content, please visit www.ebnet.co.za.
And I mean, it's back to this whole data protection mindset that I think all of us have got our heads around, where we kind of going, sure, I can't disclose children's information specifically, et cetera. And so there is this kind of overlap that I know trustees struggle with. So thank you for sharing that. Deidre, while you were chatting, I noted in the report or the guide that Bowmans did produce was a note in terms of the South African practice that an information officer, if there is a breach or an incident, I mean, I was always under the impression we had to report that to the information regulator, but there is a note in there that talks about reporting it to SAPS. Is that correct, or did I misunderstand the context?
I can jump in there, Natalia. So the obligation to report to SAPS is actually under the Cyber Crimes Act. So whilst it was our data protection guide, we did also address the issue of cybersecurity. As Deirdre mentioned, they really are going hand in hand these days. So you are completely correct that under POPIA, a responsible party, which could be a retirement fund, has an obligation to notify both the information regulator and the affected data subjects in the event of a data breach. And that's, of course, widely defined under POPIA. It's where you simply have reasonable grounds that personal information of a data subject has been accessed or acquired by an unauthorized person, We don't have a materiality threshold or a sort of risk threshold that other countries do, such as Kenya or specifically or GDPR in Europe. Any breach, regardless of the size or form of the breach or impact on the data subjects, must be reported. Now, where the SAPS comes in is our Cyber Crimes Act, which was implemented recently, and not every organization is required to report to SAPS. What is required is the Cyber Crimes Act sort of criminalizes certain offenses, and that really relates to cybersecurity, hacking, taking hold of a system or doing something unlawful in relation to it. And specifically, it refers to electronic communication service providers and financial institutions, as defined in the Act, have an obligation to report the matter to SAPS within 72 hours. So again, even though there's this obligation to report to SAPS, it's not for everyone. Okay. There's no obligation or organizations. It's limited to electronic communication service providers and financial institutions. Of course, an organization, if they are subject to a cybersecurity issue or, a sort of being held for ransom, which is often the case, you may want to report it to the SAPS. It's a good sort of initiative to report to SAPS when something criminal has taken place, and you can sort of investigate. It also may be required for insurance purposes. But under POPIA and the Cyber Crimes Act, there's no legal obligation to report it for organizations, save for, as mentioned.
Mm. Deirdre, I'm not sure if you've got any further comments around that.
Well, I'm just thinking immediately, so if you're a financial institution, as Nadine had now explained, and we know we have a specific definition of a financial institution in the joint standard, there is also clear reporting obligations to the authority, but this still needs to be tested, and I understand that we're still waiting for the authority, to the FECA and the PA then to publish the format, the why, the when, etc. But I'm just reading now on the joint standard, where it says a financial institution must notify the responsible authority, so a retirement fund in this instance, then the FECA, in the form and manner determined by the authorities after classifying the following as a material incident, which is a cyber incident or information security compromise. So effectively, you can have a retirement fund that is then a financial institution who would then need to be reporting to the information regulator, SAPS, depending on what happened, and the FECA. So a lot of reporting going on, but obviously that it's provided what had happened. With that, like I said, the joint standard clearly refers to a material incident, which is either a cyber incident or information security compromise, those terms being defined in the joint standard.
So again, we see data protection, cybersecurity linking hand in hand.
Yeah.
It's becoming exceptionally complex as an environment. And I know that certainly the joint standard, while Deirdre did nicely raise it for me, I'm going to jump on that as well. There is talk around this concept of proportionality, which I know that the industry is struggling with, particularly retirement funds. So perhaps, Nadine, maybe you can shed some light on what proportionality means legally. And Deirdre, perhaps you then can share what that means for retirement funds.
Sure. So, Natalie, in terms of proportionality, I assume we're talking about in processing personal information, in handling it, in conducting your duties under the Act, what would be sort of proportional in these circumstances, bearing in mind that retirement funds, as you said, a lot of them do appoint administrators to administer the benefits, and what would be required in this regard. Now, and Deirdre, please jump in here with your knowledge. Ultimately, a retirement fund, of course, is regarded as a responsible party under our data protection laws. That concept actually in other jurisdictions is a data controller, but in South Africa, it's a responsible party. And they are actually accountable for compliance with POPIA. You do get a concept of an operator, or commonly referred to as a data processor in other jurisdictions. And an operator processes personal information for a responsible party, subject to its instructions under a contract or mandate. Now, in the instances of retirement funds, what you often find is the retirement fund is the responsible party. They are the ones that are determining the means and purpose for processing information. They decide what information to collect about its members, about beneficiaries, etc., why they need that information and for what purpose they're going to use it. They then may appoint an administrator, and the administrator is simply an operator. They act on the instructions of the retirement fund. Yes, they may make suggestions about it's better to use this system or let's do it in this manner that's more, beneficial, but ultimately they're not determining what information is being collected and for what purpose. So when it comes to, proportionality, one just needs to bear in mind that it is the retirement fund that is accountable under POPIA. The administrator actually doesn't have liability under POPIA. Currently, our Act is drafting in the manner that the liability and responsibility is solely with a responsible party. An operator cannot be held liable. I don't necessarily agree with this, and where this actually comes from is our laws. POPIA was drafted on the basis of the EU Data Protection Directive, which is the previous European laws. It's identical. Under the GDPR, which took over those laws, they now acknowledge that, no, maybe data processors should have some liability and they should have some duties. So we may see, obviously, our Act change and acknowledge that there should be more accountability on a processor side, but currently it's the responsible party. So just bearing that in mind, a retirement fund does have to actively know what information it's collecting and processing it. It needs to assess, as you said, what is adequate, relevant, and not excessive. Are we only collecting stuff that is purely necessary, and how are we processing it? Is it secure? Is it subject to adequate safeguards? Can data subjects exercise their rights to the information? How do we ensure that they can exercise their rights? All of those obligations are on the fund, and it's sort of a test of ensuring that you have a lawful purpose to do it, but you're doing it in a manner that is reasonable, it is required, and it's in accordance with your functions and duties as a retirement fund under the Pensions Funds Act. I'm not sure if that particularly answered your question, but Deirdre can definitely share some more light on her views in respect of funds specifically.
I think it's exactly that. It's that whole thing that you can delegate but not abdicate. So the buck stops with the trustees. So the advice there would probably be to have quite a watertight SLA in place. Obviously, I think a retirement fund, provided that the administrator, if the agreement is quite clear on these are your parameters, this is the purpose, this is the use, you can't, that's contractual. If the administrator were to breach that, then obviously the retirement fund would have contractual or delictual claims. It's not necessarily only that the retirement fund that, would be held liable, but I mean the data subject and the information regulator is going to look at the retirement fund and not what the administrator had done. But yeah, I can't really add to what Nadine had said. It stops with the fund for now.
For now. So proportionality then applies to cyber compliance, but not to POPIA compliance. Is that a kind of a fair summary of it?
No, it depends on. So I'm going to give you a typical lawyer response. It depends.
I knew I was going to get it somewhere.
It really depends. I mean, the joint standard POPIA applies to everybody, right? Sure. And then you have the specific definition of a responsible party. And then in the joint standard, you have the definition of a financial institution, which includes a retirement fund and it includes its administrator. So when it comes to systems, and they're different things. So the joint standard, as an example, doesn't deal with paper, right? It's just systems, IT systems, cyber, etc., where POPIA is broader than that. Can be paper-based, it's a lot broader than that. So it depends on what has happened. the joint standard makes it very clear that the financial institution must have also a SLA in place with a third party, i.e. your administrator, where those systems, etc., is operated by or controlled by the administrator. So I don't think a retirement fund can necessarily say, well, you know, if you look at it practically, which is the retirement fund, we are board of trustees, all of our information sits with the administrator. Administrator, you comply with the joint standard, not us. You know, the FSCA is not going to test it like that. The FSCA is going to check whether or not the trustees, you know, the fund also complies with the requirements of the joint standard. And again, it boils down to what your SLA says. And again, you can't abdicate those responsibilities and just say, well, you guys sit with the system, you comply. Unfortunately, fortunately, the retirement fund still has those obligations, and both have the obligations in terms of both act. You know, as a operator, you know, administrator also needs to comply with POPIA. So both acts apply to both parties. I hope that helps. I hope that answers.
Yeah, definitely. Thank you. And we've unfortunately run out of time. So I'm going to wrap it up by saying thank you so much for sharing your knowledge with us today. For those viewers who haven't yet gone to go see the guide to data protection in Africa that was produced by Bowmans, make sure you go check it out on EBnet. But Nadine and Deirdre, thank you very much for taking the time to chat to me today.
Thank you for having us.
Thank you very much.
Thanks.